Ladies and gentlemen, we have breaking news in the Justin Baldoni versus Blake Lively court case. A judge has ruled on the protective order. This is a big deal. I'm going to read the 9-page ruling right now. This was emailed out just minutes ago, so hot off the press. Breaking news. Let's get into it. I'm Dave Neal, host of the Rush Hour podcast. After you check out this breaking news story this afternoon, make sure you're subscribed. We will have more content regarding the Blake Lively, Justin Baldoni case, as we have information and belief that the ex-CIA agent working for Blake Lively is using tactics to divide and conquer as new articles come out, sort of weaponizing the political ideologies that might be trying to dismantle beliefs involved in this case. What does that mean? They're trying to keep us fighting with each other, not with our eyes on the prize. We'll have all of that information coming to you right after this. But first, here it is, the court case. Blake Lively, Justin Baldoni. Last week, it's been about a week or so. Last Thursday, this hearing happened, and again, this is to find out if Blake Lively's discovery would be allowed, or if she'd be, her plan was to say, due to the PR nature and the salacious tendency of people to pick up on every part of a story, we don't think we should have to present some of our text messages in discovery with our high-profile clients, that being Taylor Swift and whoever else. Some people say Bradley Cooper and whatever other friends of Blake Lively might get sucked into this. So that's what the protective order request was for. Justin Baldoni's side argued that they think that she shouldn't receive any preferential treatment because she's famous, and we need to see all this information. We'll redact it, we'll keep it from the public, and they say, no, you'll leak it. So here's what the judge has to say. Blake Lively versus plaintiff, which is Wayfair Studios, and then we have Wayfair Studios, plaintiff versus Blake Lively. So they're kind of both suing each other, so it's all in one. Judge Lehman, United States District Judge, whereas all of the, and by the way, he's going to be able to issue like a full protective order or partial, so we're going to have to just see what this is all about. Whereas all of the parties to this action, collectively the parties and individually a party, request that this court issue a protective order pursuant to Federal Rule of Civil Procedure 26C. To protect the confidentiality of certain non-public and confidential material that will be exchanged pursuant to and during the course of discovery in this case. Whereas the parties acknowledge that this protective order does not confer blanket protections on all disclosures or responses to discovery, and that the protection it affords only extends to the limited information or items that are entitled under the applicable legal principles to confidential treatment. Whereas the parties further acknowledge that this protective order does not create entitlement to file confidential information under seal, and whereas in light of these acknowledgments and based on the representations of the parties that discovery in this case will involve confidential documents or information the public disclosure of which will cause harm to the producing person and or third party to whom a duty of confidentiality is owed, and to protect against injury caused by dissemination of confidential documents and information, this court finds good cause for issuance of an appropriately tailored confidentiality order governing the pretrial phase of this action. So there's a protective order. Again, it's going to be limited to what they think certain mental health issues, maybe issues involving children, the address of their homes, things like that. Okay, fair. It is, and I think the judge is doing a good job so far. So my hope is that he's going to be able to discern between what needs protection and what doesn't. It is hereby ordered that any person subject to this protective order, including without limitation to the parties to this action, their representatives, agents, experts, and consultants, all third parties providing discovery in this action, and all other interested persons with actual or constructive notice of this protective order shall adhere to the following terms. So we don't exactly know who's going to be a part of this protective order. So none of this really matters until we know, does it involve Taylor Swift? And again, leave a comment to the smart legal people out there. Maybe I'm missing something here. It is, so this is what they have to adhere to. Any person subject to this protective order who receives from any other person subject to this protective order any discovery material, information of any kind produced or disclosed pursuant to and in court of discovery in this action that is designated as confidential or attorney's eyes only pursuant to the terms of this protective order, hereinafter collectively confidential discovery material, shall not disclose such confidential discovery material to anyone else except as expressly permitted hereunder. So the way I believe this is like, if a file's labeled confidential or attorney's eyes only, that's as far as it goes. And that'll be their way of trying to keep it out of the public record. Because, the public is entitled to see different court papers. Everything's supposed to be public, right? Freedom of Information Act are supposed to be public. But in certain cases like this, sure, if Blake's kid has a mental issue or they don't want to, the name of the, elementary school to be, I absolutely agree. And I believe they'll do a good job of keeping that confidential because no one cares about that, right? We care about finding out, did he sexually harass her or not? So let's continue. The designation attorney's eyes only shall only be utilized for confidential discovery material of such a highly confidential and personal, sensitive, or proprietary nature that the revelation of such is highly likely to cause a significant competitive, business, commercial, financial, or privacy injury to the producing party. The following categories of information may be designated attorney's eyes only. And that's supposed to be for the PR people because, they've got such a private client list, and no one needs to share their proprietary blend of how they call Us Weekly to plant a story. Get over yourself. Trade secrets, confidential business plans, marketing plans, strategies for clients other than the parties in this litigation, confidential business projects or leads on projects for clients other than the parties in this litigation, confidential creative projects or ideas other than those involved in this litigation. Security measures taken by parties or third parties. No one cares about security measures. Although, if you have a security person by your side, I think they should be subpoenaed because they might have information, that helps the case. Although, why would a security person talk poorly about the person that hires them? Medical information of parties or third parties, highly personal and intimate information about third parties, and highly personal and intimate information about parties other than information directly relevant to the truth or falsities of any allegations in the complaints in this case. So they're laying out the ground rules for what's involved and what's not. And I think this is a good thing for both sides because, you hate to say, we didn't share this because we were afraid. You get that defense. Someone didn't want to, go up on the stand because they were afraid. It's like, well, they're putting in as many protections as they can. The protections conferred by this order cover not only confidential and attorney's eyes only information, but also any information copied or extracted therefrom, as well as all copies, excerpts, summaries, and compilations thereof, hereinafter referred to collectively as copies. So you can't just scan a copy of somebody's thing. The person producing any given discovery material may designate as confidential or attorney's eyes only such portion of such non-public material, the public disclosure of which is either restricted by law or will cause harm to the business, commercial. So if I'm part of Blake Lively's team and I wanted to share something, I could say this is attorney's eyes only, but I'm guessing that the judge would get the final say on that. Like, you'd have to prove why it's, and again, this will really slow things down if you just like a la carte style every single piece of information. But hey, what can you do? Previously non-disclosed financial information, including without limitation profitability reports or estimates, percentage fees, because they're going to have to prove all of this. If you're going to prove defamation, you have to prove how you lost an income. It's going to get salacious, what you charge, all of that. Previously non-disclosed material related to ownership or control of any public or non-public company. So they go through all of that information. With respect to the confidential or attorney's eyes only portion of any discovery material other than deposition transcripts and exhibits, the producing person or that person's counsel may designate such portion as confidential. So they talked about that. They'll designate it, what's confidential, what's not. With respect to deposition transcripts, a producing person on that person's counsel may designate such portion as confidential or attorney's eyes only, either by A, indicating on the record during the deposition that a question calls for confidential discovery information, in which case the reporter will bind the transcript of the designated testimony. So they're saying they'll conceal whatever they need to. If at any time prior to the trial of this action, a producing person realizes that some portion of discovery material that she, he, or it had previously produced without limitation should be designated as confidential or attorney's eyes only, she, he, or it may so designate by so apprising all prior recipients of the discovery material in writing. No person subject to this protective order other than the producing person shall disclose any of the discovery material designated by the producing person. So they go through all of the actions here. What we're going to have to find out is how much of this will the judge be able to decide, because obviously if you say everything is attorney's eyes only, then it's ridiculous, right? So I guess the judge will have to decide what is fair and what's not. And they're going to try to push the line as much as possible. My guess is that Justin Baldoni's side won't have much to hide. But, if these are the rules they're playing by, maybe he'll try to hide some financial information or things like that. And I say hide, but it'll be out of respect to, protecting his own family, just like Blake Lively's going to want to protect hers. The question that people have is it about protecting your family, but will you use that protection to try to hide some of the truth from coming out? In the event the fact witness refuses to sign a copy of the exhibit, he or she may be shown confidential discovery information only after on the record stating such refusal, and then being advised on the record of the following. By order of the court in this action, you may not disclose in any manner any confidential discovery information to any person or entity except in strict compliance with the provisions of this court. All right, so they have some pretty strict rules here with regard to getting the discovery. Recipients of confidential discovery material under this protective order may use such material solely for the prosecution in defense of this action, and any appeals thereto, and specifically and by way of example and not limitations, may not use confidential discovery material for any business, commercial, or competitive purpose. Nothing contained in this protective order, however, will affect or restrict the rights of any person with respect to its own documents or information produced in this action. So, look, seems pretty fair to me. Again, maybe there's something in here that's above my pay grade that I don't understand. All persons are hereby placed on notice that the court is unlikely to seal or otherwise afford confidential treatment to any discovery material introduced in evidence at trial or supporting or refuting any motion for summary judgment, even if such material has previously been sealed or designated as confidential. Okay, this is interesting. Because you have the trial and then you have the pre-trial, right? And in the pre-trial, that's where you share your discovery. Both sides have to know what each side has so that they can argue for or against that. And here the judge is saying that the court is unlikely to seal or afford confidential treatment to any discovery if it's actually used as evidence. Any party filing a motion or any other papers with the court under seal shall also publicly file a redacted copy of the same. Each person who has access to discovery material that has been designated as confidential or attorney's eyes only shall take all due precautions to prevent the unauthorized or inadvertent disclosure of such material. Any personal identifying information, social security numbers, party phone numbers, addresses, other than those already made public for personal services, those are also going to be protective order. Sure. This protective order shall survive the termination of the litigation. Within 30 days of the final disposition of this action, all discovery material designated as confidential or attorney's eyes only, and all copies thereof, shall be promptly returned to the producing person or, upon permission of the producing person, destroyed. All persons subject to this protective order acknowledge that willful violation of this protective order could subject them to punishment for contempt of court. This court shall retain jurisdiction over all persons subject to this protective order to the extent necessary to enforce any obligations arising hereunder or to impose sanctions for any contempt thereof. So ordered, March 13th, 2025, Louis J. Lyman, United States District Judge. And there it is. So he stayed, I guess he's going to sign this part. I agree that I will not disclose confidential material. And then I guess they all sign it, right? They all acknowledge that they have read and understand the protective order in this action, and they will not disclose it. So if something's labeled protected, then it ain't yours to share, and we'll respect that. We'll respect that the judge is going to have a pretty good idea of what's protected and what's not. Well, my question is, what's next? Do they have to just share it all and then individually bring things to the judge and go, nah, that's protected, that's not? Because we saw the other day, it was like a 2-hour phone call. Are they going to have a phone call where they argue why they want something protected? The judge is no nonsense, but time really adds up. This is going to add a lot to the billing, but I guess both sides have a lot of that Mint Mobile money, right? All right, there's your update. Any further updates we have, as I'm sure a bunch of lawyers will analyze this and pick it apart, I'll bring that back to you. Make sure to subscribe if you aren't already to the playlist, the Rush Hour Podcast, every morning, every afternoon. All the news you need to know. So go check that out. And we'll be back with that coming next.